captioning. If you would like to use captions, you should have a box that says show captions at the bottom of your screen, and then you can select your language of choice. We did not receive any requests for additional accommodations or languages, so we are going to present today in just English. Okay, so we'll go ahead and get started so that we can take advantage of all the time we have today. Good morning, everybody. My name is Kristen Stratton, and I am one of the admins from Go Bananas. I'm also a parent of 3 children, all of whom have a diagnosis of some sort. And I am also a special education advocate and a disability rights advocate. So it's my pleasure to introduce our speaker today, Jeff Nickerson, who is doing a 3-part series for us to share his knowledge, his expertise as a experienced attorney, and he's also a parent of children with disabilities. So not only does he have the legal expertise, he's also got the personal experience of accessing these benefits and utilizing a lot of these legal tools he's going to be sharing with us. Today we're talking about trusts, special needs trusts. We also have a third series next week, I believe on Tuesday, talking about limited conservatorships. We've already discussed all about the legal benefits and various programs available to our children. That was before Thanksgiving. So if you have any questions about those specific things, we do have a Q&A at the very end. We can probably touch base on those things again. But today we're going to be mainly focusing on trusts and estate planning. And with that, I'll hand it over to Jeff.
Well,
Oh, I'm so sorry, Jeff. I wanted to mention about questions. So let me interrupt you just really quickly. Please feel free to use the chat box. And he loves interaction. So please put your questions in the chat box and we'll throw them out to Jeff throughout the presentation.
good morning. That was perfect, Kristen, because that's exactly what I was going to say. Having people ask questions and making this program interactive, I think really adds a lot, and it helps me understand if I'm communicating well or need more clarification. So please feel free to jump in anytime. I see everybody is pretty much on mute, so if you can stay on mute unless you have questions, that also helps the background information. I love doing these presentations. As Kristen mentioned, I've got 2 adult sons, one diagnosed with cerebral palsy and one diagnosed with autism. And so I kind of been through it myself, just like all of you, through the schools, through the education, through the IEPs, through the regional centers and all that kind of stuff. And that's exactly why I got into this area of law, was to um, uh, learn and share knowledge about this. So let me pull up my charts here and we can start right off here. Okay, so you should be seeing something that says special needs planning, and we'll be going for about an hour. I'm very into respecting your time, so we'll finish up by 11, but I'll hang around for questions and so forth well after that if there's an interest. So a little bit about me, lots of education to get to this point. I'm very involved in multiple organizations that involve special needs planning, National Association of Elder Law Attorneys, NALA, which is a nationwide advocacy program, and education program dealing with elderly and special needs. I don't even have this next one on here. I just spent several days attending what they call a CANAR presentation up in Northern California. It's a California I actually forgot the acronym, but it's for elderly and special needs planning, dealing just in California. And as most of you already know, California has very different benefits, much better benefits than just about everybody else in the country. So it's important to be knowledgeable about those benefits. Whenever we're doing special needs planning, we're also doing benefit analysis, very important. Very involved in Special Olympics. Just a couple weeks ago, I was at the big softball tournament in Costa Mesa. That was great fun. Involved, and I started my own. We all started our own nonprofit several years ago, and that's been very successful. Anyways, I love talking about special needs planning. We always have to have a disclaimer. We always say this is for legal information and not specific advice. So why do we say that? The reason is it's critically important. It's very factual based whenever you're giving advice. For example, if somebody's receiving SSI, my advice is going to be very different from them than for only receiving SSDI. So that's why when you're listening to this, it's important to remember that it's legal information. So why plan for special needs? There's really two major reasons. You want to maximize and coordinate those government benefits, which are so generous here in California, and two, set up a life plan structure for them for really the rest of their lives. Those are the two key aspects of it. Really, whenever we're doing special needs planning, we're also doing family planning almost always at the same time. The two are coordinated and very tightly connected. You really can't do one without at least some of the other. So here's the agenda. I'll be talking briefly about general estate planning. I don't really have any specific specific charts on it that go into detail, but I can certainly address any questions that may come up. Special needs planning. We're going to talk about what is this concept? What is this thing called a trust? What does that mean? We'll be talking about that. And then there's several different types of what we call special needs trust. So the special needs trust is a particular type of trust, and there's multiple special needs trusts. What things should you not do when you're planning? What mistakes that you should definitely avoid? We'll talk about drafting, a little bit about drafting. I'm not going to get into a whole lot of detail. Selecting a successor trustee and is probably your most difficult challenge in drafting documents. Fortunately, they can be changed, but that's going to be one of the most difficult and most important decisions you make when you're setting up whether it be just general planning, and of course, more importantly, special needs planning. We'll be talking about the role of a trustee, funding, and who needs a special needs trust. And then there's a lot of other topics out there. There's the world of special needs planning is broad. There's a lot to it. One thing I always have to say, I know some of you are probably know more about some of these topics than I do. I know last time Kristen had some great information on some of the education and IEP procedures that I was not aware of. So I always come from these presentations learning something new. So what is a trust? What is the concept of a trust? Think of a trust as a bucket, okay? So what you're going to do is you're going to put your stuff in this bucket. We're going to put your house, maybe if you have other property, maybe accounts, all this stuff. This bucket sits outside of you. This bucket is actually a separate legal entity, kind of like a corporation, but it's not. It's a trust. It's even though it's in a separate bucket, you control all the stuff in this bucket, just like you owned it yourself. So what's going to happen is that the trust is going to own the stuff in the bucket, and then you own the trust. Trusts have been around for hundreds of years. They date back to Old England. There's always three roles in every single trust. There's always three roles. The first role is that of a trust maker. The person who's a trust maker makes the trust. Also called, other terms are settlor, grantor. I like the term trust maker because that's obvious who it is. Who is a trust maker? It's going to be most likely you that's listening to this. It's going to be most often it's going to be the parents who are the trust makers. They're making the trust. The second role, but same people, is trustees. The trustees are the ones that manage the trust. So they're the ones that are going to pay the bills out of the trust. They're going to spend money. They're going to put money into the trust. The trustee is the ones who manage the assets in the trust. Actually, it's kind of being a trustee is the busiest role. And finally, there's the beneficiary. Whenever we're talking about a special needs trust, the beneficiary is going to be the special needs individuals, could be single, could be plural, that you've named our special needs family member. I always get the question about what is the difference between a revocable trust and an irrevocable trust? When it comes to what I'll call family trust, and most trust, in addition to special needs trust, start off as revocable, which means you create this trust, you put a bunch of terms, who's going to be your successor trustee, how you're going to leave your money, various instructions to the trustees, those type of things, and those all can be changed. Everything can be changed as long as it's revocable. Once it becomes irrevocable, you can't change it. Now, that's not a bad thing because in order for it to be a valid special needs trust, it has to become irrevocable at some point. And in fact, we have a sort of a backdoor way that we can change an irrevocable trust also. So the fact that it's an irrevocable trust is not a bad thing. It's actually a good thing. So when it comes to special needs trust that are irrevocable, those funds in that special needs trust that has become irrevocable are locked away. Nobody can get those funds. Creditors, evil people, they can't get to those funds. They're locked away. The only way those funds can be spent is on your special needs individual. If they're spent in any other manner, there's a criminal act going on. So it's a very valuable tool. So let's talk briefly about the family trust and the special needs trust. More often than not, when we're doing a special needs trust, we're also doing the family trust, or we're modifying a family trust that's already been created. So think of it as two buckets. So you got the one bucket, maybe the primary bucket, I'll call it. I always call it the family trust, and that's going to really address the parents and all of their assets. It consists of a whole bunch of documents. Briefly, I've got a list here showing here. There's a trust, a community property agreement, pour over wills, powers of attorney, healthcare directives, property transfers, a whole bunch of things. I could spend an hour talking about each one of those items, but that's not the purpose of the day. The purpose of the day is to focus on that special needs trust. Anyways, we create this bucket, this family trust, and then as the beneficiary portion of it, you're going to name your special needs individual. Well, you're not going to really name the special needs individual. You're going to name the special needs trust we've created for usually your child, and those funds will then go into that secondary bucket that we've created, and that's the special needs trust. At some point, that'll become irrevocable, and those funds can only be spent for your special needs family member. Clearly, the best way to protect benefits being received by somebody that's developmentally disabled, to protect those government benefits, is with a third-party special needs trust. I'll get into the types of special needs trust here shortly. I do want to clarify that there's the term special needs trust and there's a term supplemental needs trust. They mean exactly the same, okay? Different terms, same documents. So sometimes we'll have, unfortunately, we have, let me rephrase this. Sometimes we have very high functioning people or people that have other issues that maybe not be developmentally disabled, and they don't like the term special needs. That's why I think is unfortunate. So anyway, so if we have that situation, we'll just call the trust a supplemental needs trust instead of a special needs trust. That's the only difference there. Okay, this is an important area. There's three different types of trusts: a first party trust, a pool trust, and a third party trust. And I'm going to repeat this a couple times. A third party trust is not the disabled party's money. It's not your son or daughter, family member's money, trust. It's your trust, the trust maker's trust. It's not the disabled individual's money. It's your money. But the disabled individual is the sole beneficiary of that trust. So let's go through the three types, and I'm going to go through the first party trust, pool trust, and we're going to really focus on third party trusts. So let's talk about first party trust. This is the trust that we often have to put together because of either poor planning or some sort of unexpected situation has occurred. So first party trust occurs when the disabled individual receives money in their own name. This can be in a poorly planned inheritance. We'll see this maybe in a personal injury, or a workers' comp injury, where the person receives money, or it could be a outside gift, whatever. So when this happens, when somebody receives money that's receiving benefits, oftentimes it'll end their benefits. This can be a huge impact. They could lose their SSI. They might lose their Medi-Cal, and it can create real problems. So the state has come up, actually the federal government has come up with through the laws, regulations, permitting somebody to set up a first party special needs trust. But there's several restrictions on that. The advantage about a first party trust is the money goes into this trust, that same bucket we talked about, and any money in that bucket doesn't impact benefits. So it doesn't count for SSI, Medi-Cal, or anything. That's the good thing. And so the money can then be spent for the needs of that individual until they pass away. The big negative about a first party trust is that when that person passes away, the state Medi-Cal agency is going to come in and sweep up any remaining funds in that trust. So it's not a good way to transfer funds to family members and so forth. But sometimes it's the only option. And this certainly occurs in a personal injury situation, or some sort of a court-directed trust. This will often occur. Though it's disheartening when it happens that somebody didn't plan ahead and family assets go into a first party trust instead of a third party trust, and the state's going to come in and take those funds. So first party trust is a valuable tool, but we certainly rather use a third party trust instead. And there's some very specific rules on a first party trust. It can only be created by somebody who is under the age of 65. I've had in the last 2 months, I had somebody who was still receiving SSI because they had not contributed hardly anything to Social Security during their lives. They were in their 70s, and they received they received an inheritance. So typically what we would do is we put those money in a first party trust so it wouldn't impact their benefits. In this situation, we could not do that. We were able to find some other solutions, some other workarounds and so forth, but sometimes that can be a real problem. It can only be created by a parent, grandparent, or a legal guardian or a court. I had another case recently where a gentleman received funds from, I forgot exactly where, but it wasn't from a legal action. The problem was the parents had passed away. There was a sibling, but they didn't have the authority to create the trust, so we had to go into court. One of the good things is a beneficiary themselves can create a first party trust. So if somebody is injured, let's say in an auto accident, then they can create their own first party trust. I'm not going to spend a whole lot of time talking about this, so that's why I'm spending some more time talking about this. It's a tool that we use. Probably 10% of our special needs trusts are first party trusts. This last thing about a beneficiary being entitled to create their own trust was really huge. It was the very last act of the Obama administration. For years and years, a beneficiary of a first party trust could not create their own first party trust. Terribly unfair, because the underlying assumption was anybody that's a beneficiary, anybody that's disabled can't can't create their own trust. And in fact, we know lots of people who are disabled for one reason or the other, are highly competent, but were forbidden by law to create their own first party trust. That was changed several years ago. A good thing. Pooled trust. I'm going to talk very briefly on this. I am not a fan of pooled trust. Um, Pooled trust is money that comes in as they're organizations, nonprofits that will accumulate funds, um, um, and they're separately accounted for. And monies in a pooled trust can then be spent. Um, for, Monies in a pooled trust will not count against various benefit programs. That's the good thing. Um, but they don't do anything else. All they do is hold the money and then write checks on behalf of the individual. It it works out well for somebody who is, let's say, it's essentially it's a check writing service. And so it might work out really well for somebody who was, let's say, injured in an auto accident, um, fully competent, receiving benefits. They can put money into that pooled trust, and then the money in that pooled trust, let's say from an insurance award, wouldn't count against benefits they're receiving. And then the nonprofit would just write checks out on their behalf as needed. It tends to be a bit bureaucratic. One of my other concerns is that if there's any money remaining in that pooled trust, the nonprofit that runs it has to be a nonprofit, will generally keep those funds. There's some exceptions to that. Personally have a real concern about that. The I think there's a tension there, an obvious tension. Um, I've had two or three clients that we prepared pooled trust for several years ago. I thought that would be appropriate. All of them were unhappy. They were slow to write checks. They were not responsive. They don't provide any sort of help or support. And certainly for our special needs community, one of the great aspects about a first party and especially a third party trust is providing that support and help and guidance, which just isn't there with a pooled trust. Excuse me, my pauses while I'm drinking water. Um, the most common trust and probably the most advantageous trust is a third-party special needs trust. So a third-party trust means it's not the beneficiary's money, it's somebody else's money, typically the parents. So typically what we see is a family trust is created. They'll leave funds from that family trust that goes into that third-party special needs trust. That third-party special needs trust is also protected. That's what the big advantage is, that money in that third party trust does not count towards any sort of benefits. And then it also sets up a lifetime plan on who's going to manage those funds during the life of that individual. The key thing is that key thing that distinguishes it from a first party trust, there's no payback provision. That means there's no ongoing accountings and so forth, which I forgot to mention about a first party trust. Is in a first party trust, because there's a payback provision, the government has an interest in those funds, wants to make sure they're being properly spent, and so will often has the right to audit all the expenses of a first party trust, and they do so. When it comes to a third party trust, technically the agencies, Social Security and Medi-Cal, can audit expenses out of a third-party trust. Frankly, I've never seen or heard of it happen. I'm sure it's happened at some point. I just have never seen it because there's no motive for them, because the government's not going to be able to keep that money anyways. Again, it's not the disabled party's own money, it's not your special needs family member's money. It's your money you left for them. It's not their trust. It's your trust, but the disabled individual is the sole beneficiary. So I'm going to give you a quiz. It's the only time we're going to have a quiz today. And so at some point, it's highly likely that if you're being interviewed for Social Security and Medi-Cal, you're going to get the question, does your son or daughter with special needs, do they have a trust? And what is the answer? No. They don't have a trust. You have a trust. Not their money, it's your money. The reason I see this, I bring this up and emphasize it because I see this all the time. Probably a couple times a year, I get this panic phone call that they were interviewed by Social Security or Medi-Cal. They asked the trust question, and they said, "Oh yes, my attorney Jeff Nickerson, he prepared a special needs trust." And they go, and the worker says, "Oh my goodness, we didn't know about that. We've been giving you overpayments and so forth. We're going to charge you, and you're going to have to return all the money and so forth." And the clients come into my office. I'm in a big panic, and I said, "Don't worry about it. If they didn't realize it's a third-party trust, go ahead and send a copy of the third-party trust, and the issue will go away, and it always has. It also has proved that our trusts have passed the formal audits. But anyways, that comes up so often that I make sure I bring that up. Special needs trust. It's certainly the best legal structure to protect special needs family members. Maybe now's a good time for any questions that have come in, Kristen.
Right now, we just have one that came in, and the question is, what happens when the trust owner passes away and who owns the trust?
So when the trust maker, referred to as the owner, when the trust maker, when they pass away, there's language in the documents that will address that specific issue. So from the standpoint of the successor trustees, when the special needs trust is created, just like a family trust, uh, the trust makers will almost always be the trustees also. And then we'll name successor trustees. We always try and name three if possible. And so then the successor trustees will step right into the role of the parents. So we always trying to name some younger individuals that'll just step in, and the trust just continues.
And then
So
we have one more question that also just came in subsequent to that. It says, can property be put into the trust or just money?
no, it's that you can put property, you could put businesses if you wanted to. You can really put in any asset that you wanted to put into a trust. We'll talk about that a bit more. One of the things that sometimes concerns me is people want to leave let's say, the family home in the special needs trust, and that's fine and good. We do that frequently, but also remember that that family home is going to require ongoing maintenance and so forth. So it really needs to be funded with some liquidity also so that property can be maintained. But we do that frequently, where the family home is left, and rightfully so, because you're concerned about what happens when you're gone, and where's your family member going to live. So it's certainly that can be done.
And you're all caught up on questions for right now.
Okay, so I got to tell you what happened yesterday. Just yesterday, 1 o'clock, I had a meeting with several people, and so Dad passed away, and he had an estate worth $500,000. He had set up no estate planning, nothing for him, no general estate plans. He had two children, one of them being a special needs individual, age 45, and he was significantly disabled, living in a group home in Orange County, Placentia. And I could tell that it was a very good situation. They were they He had successfully found a good home. The Medi-Cal was paying $11,000 a month for this group home, and everything seemed to be going very well. Now, he passes away, no planning, so now we're in probate court. Probate court is long and expensive and so forth. But now this individual is going to receive these funds directly. This creates a whole bunch of problems, in that what type of benefits he's receiving and so forth. So there was a lot of analysis I had to do without getting too into the weeds. But what's going to eventually happen is either those funds, the $250,000 that's going to special needs individual in a group home, is going to be used, is going to cause the Medi-Cal payments to be stopped, and then those funds will be drained until they're down to zero. Then he'll go back on Medi-Cal, or we'll create a first-party special needs trust, and the funds will be sitting in that first-party special needs trust. However, when he passes away, under the terms of the first-party special needs trust, all those funds will go back to the state. Bottom line is, all those funds that went to his son are going to be used to replace government funds. I'm sure that was not the thinking of Dad before he passed away. Um, the 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 sister had contacted us because she thought we could set up a trust that would protect those funds. And once uh, brother, especially his brother, passed away, she would receive those funds or whatever was remaining of those funds. Where in fact that was not the case because there had been no planning. Those funds will be consumed by the government, or it will replace government benefits. And so, unfortunate uh, result that if Dad had just done some advanced planning, had set up a state plan for himself and a special needs plan for his son, it would have allowed extra funds to be left for son to be used for whatever needs he had, a better TV set in his room or a better bed or whatever to improve his quality of life. And then assuming funds were left over, then it would go to the other adult child. A real life example. Unfortunately, I get these almost monthly. Nearly monthly, I get these phone calls where somebody has left money to their special needs individual. Typically, the ones I get, and this happens at least monthly, grandparents. And grandparents are wonderful when they do this. And with the best intention, they decide to leave 50, 70,000, 80,000. That seems to be the common number that they've left to their special needs, a grandchild who's probably now an adult that is receiving, that's developmentally disabled or receiving other kind of benefits. Those funds are going to impact those benefits, and now we're running around. How can we protect those benefits from getting just eaten up by the government?
You did get a couple clarifying questions.
Sure.
The first was regarding putting a property in the special needs trust. The question was, does the property have to be maintained by the trust or can it be maintained by an individual?
Um, so the house can be so the funds to maintain the house can become from come from an individual. So it doesn't have to. So the funds to prepare the house could come from outside the trust. So that's we get into some issues as to whether that there's some outside funding that the person's on SSI, would that impact his benefit? But I don't want to get too into the weeds on that. That would be a side issue that's workable. The problem I see in having an outside person funding funding the expense of the house is there's no legal requirement for that. So what happens if that person decides not to provide funding for that house any longer? And then what? And you don't want to get a situation where you're having to sell property at distressed property or having to do a rush sale because there's not enough money to maintain it. So,
I think that that is the only question, right? With that, you also have someone who's probably going to be reaching out to you regarding some nuances with an older parent with the need for a trust review and then their own trust review.
yeah, so like I said earlier, one of the things that that really drives special needs planning is the unique situation, family situation. So we're always looking at, what benefits are being received, and then how do we make sure we maximize those benefits. So there are a lot of nuances whenever you're looking at how to best structure special needs planning. Um, so what not to do? An outright inheritance. So I see this a lot. People just leave money directly to uh, their disabled individuals. I really see this more with usually the parents are on top of this. So it's not necessarily the parents. It's usually the grandparents or some other outside individual that's leaving money directly to our special needs family member with all the best intentions, but uh, it's there's so many easier solutions to getting that third party special needs trust set up in advance to avoid that. Disinheritance. Oh my goodness. I mean, I thought that people had stopped doing disinheriting their children, you know, 10, 20, 30 years ago, because it just bothers me to think about disinheriting your own child. You do not need to disinherit your child. Um, there's other solutions to provide funding for your disinherit for your special needs child without disinheriting them. I had a client just 6 months ago, had just got off the phone with an attorney who recommended disinheriting. And I thought, oh my goodness, no, 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 no. I hear this other one quite frequently. I'm going to leave my assets to his brothers or sisters, with the help of taking care of so we got Johnny who's disabled. I'm going to list all my money to Sister Sue, and Sister Sue is going to take care of him. And I believe she's going to do that. Um, I think there's some serious problems with that. First of all, is it fair to Sister Susie to leave the money and leave that responsibility to taking care of Johnny, um, and have that decision-making process? The problem is that what if, Sister Susie has her own family members, they're in some financial difficulty, and maybe with the best intentions of using funds, they're just so strapped. You're putting a lot of just mental strain on somebody having to make those decisions. Where if it's all laid out and this is how much money goes, this is how it's going to be structured, in a very disciplined and formatted way, I think it makes it a lot easier and takes away the mental strain. Other big negative about what happens if you leave money to Sister Sue to take care of Brother Johnny is it's subject to creditors. So what if Sister Sue had an at-fault auto accident and forgot to pay her auto insurance bill? And suddenly she gets sued. They come in and take her assets. Those funds that were left by parents for the benefit of disabled Johnny is now going to be taken by the creditors because it's not walled off. Funds that went directly into a third-party trust, they're walled off. Creditors cannot get into that walled off special needs trust. Hugely important. Another common problem we see when you're leaving money to Sister Sue is Sister Sue gets the money, puts it into a joint account with husband, and then shortly thereafter, or maybe years later, they get divorced. Well, now that's community property. When they split the assets, half the assets that parents left for intended for Johnny, now divorced spouse is going to receive those. And then what happens when the unexpected passing of Sister Sue, and who's going to where are those funds going to go to? So there's a lot of problems about leaving money, and I hear this a lot. I mean, I bet I almost weekly. Oh, I can't make a decision on who to leave money to. I'm just going to leave it to my one daughter. She can figure it out. I think it puts a lot of strain and stress and can create a lot of problems. I think one of the biggest challenges in establishing and setting up a special needs trust, this is true with any sort of trust, but especially when you're doing a special needs trust, who are you going to name as a successor trustee.
You have a couple questions. Would you like to wait or would you like them to be asked now?
So let's address those questions.
You have a clarifying question just to reiterate whether or not the grandparent should leave the inheritance directly to the trust or to the name of the child.
So absolutely, it's very important to leave the any funds to the name of the trust. And I think typically most um, special needs attorneys will actually provide a letter, a separate specific letter that has the name of the trust, a short letter explaining why to do this, why it's beneficial, and with a specific language. But yes, it's very important to have the specific language of the trust named in either the will or trust, or if you're going to write a check.
Okay, and then you have two questions that I think are related, but maybe not. The first is, can money in a special needs trust be used to purchase a home in the parent's name? And then the second part is, what are the benefits of this versus putting the home in a living trust?
Sure. So one of the things I did not talk about, so that's I'm thank you for that question. So the way you get property into the trust, the rule about putting something in a trust, the way you get that into that bucket is if it has a title, you have to retitle that to the name of the trust. So if you're going to put it in the Jones Family Trust, you're going to say Mary and Fred Jones, trustees of the Jones Family Trust, dated December 4th, 2024. And that's the way you get it into the trust. So so to answer your question, you could not put a trust, and you can put a piece of property into a special needs trust in the name of somebody else. It would have to be in the name of the trust for it to be in the trust. Now, I think the second part of the question is, could you put it into the family trust if I'm reading into the question? And so typically that's what happens. So typically when we're creating a general needs trust and then a special needs trust, typically what we'll do is we'll put the home in the what we call the family trust. And then if the family wants to leave the home to the special needs trust, then we'll put that language in the trust. Or maybe they don't, maybe they'll, and they don't have to specify. Maybe they just want to say a certain percentage of the trust will go into the value of the home will go in the trust. I hope that answers the question.
I think so. And then the follow-up question to that is, what happens in that scenario if the beneficiary then passes away?
So the special needs beneficiary passes away. Excuse me. There's specific language in the special needs trust that addresses that. And there's a couple different ways that can happen, depending on, again, the specific situation. Sometimes we'll just have it circle back to the family trust, and the family trust maybe leave funds to other siblings or to charities or that. So that language, it can either circle back to the general needs trust if the parents aren't sure what they want to do, or if they're sure they want to go with the money to go to siblings or a specific charity and so forth. The language can be specifically written into the special needs trust. I guess one of the things I should mention is whenever any trust, a family trust or a special needs trust is created, these are your documents. It's your words, your language, whatever you want. We can be put in this trust.
I think we're caught up on questions for right now.
So when creating a trust, there is some very specific rules and language that must be included in the trust. Uh, when we create a first party special needs trust, the opening paragraph quotes all the federal statutes and and it's very detailed. A little bit lesser extent to the third party trust. There's got to be very specific restrictions um, since the beneficiary in a third-party trust it's not his funds. So he cannot be a trustee. He cannot control who the trustees are going to be. He can't um, um, uh, remove a trustee. He can't be a trustee. He really has zero control of that trust. One of the things that we um, we I'm a big advocate of is having a separate standalone trust. And sometimes a lot of people will put special needs language in a trust as part of the family trust. And I do not recommend that. It becomes very cumbersome to manage a special needs individual using a family trust where the family members may have passed away decades earlier and so forth. And it becomes confusing to really everybody. So we always have separate standalone trusts. Um, Another key document, which I think can be very important, is a memorandum of intent. So really, so what a memorandum of intent is, it's a separate standalone document. I would call it a living document that you update and as you determine is appropriate, and you can share information about your special needs family member, what they like, what they don't like, things they like to do, and things they don't like to do. Um, I find this especially important when there aren't a lot of involved family members, involved siblings. And I frequently see in our special needs community that frequently the special needs individual is the only child, and there aren't siblings. And this makes the memorandum of intent really important. I always like to chuckle. I had a family member I'm very familiar with. They have one child, currently in his young 40s, and she actually wrote a 40-page single-space memorandum of intent. Now that far exceeds anything I've ever seen, but that was pretty impressive. She had put a lot of thought and a lot of details into preparing that memorandum. So that is available. So like I said, it's a living document that you just update. But all the things, all like the wishes and stuff that you really can't put into a legal document, wishes and desires and so forth. This is an excellent way to share your thoughts. Um, I had mistitled I probably shouldn't be showing my errors. I mistitled this one title. The previous one should have said selecting a special needs trust should be on this title. So selecting a special needs selecting a special needs successor trustee is what this should be titled. And like I said earlier, selecting a successor trustee is one of the more challenging things to do. And you can set up, oftentimes people will set up, usually more often than not, they'll set up the children, the siblings as the successor trustees. Sometimes they'll name one, then the other, then the other. Sometimes they'll name co-trustees. There's just a variety of ways, and we actually spend a lot of time talking about that. And this is just a very individualized decision. One of the things I like to point out is a trustee is not necessarily a caregiver. Now, generally in your role as a parent, you're both. You're the trustee and you're also the caregiver. But when it goes on to when you're planning for the future after you're gone and trying to determine who would make the best successor trustee, people often have the same thought in their mind that that same person is going to have both roles. And that's not necessarily the case. Maybe oftentimes families do. Oftentimes they don't want to place that burden on the siblings. They want to have them to have their own lives. Well, they can be the financial trustee, handle the financial aspects of it, but then hire out caregiving. So that's an important factor in thinking this through. When you're selecting successor trustees, you need to select somebody who's um, got some good business acumen, knows the concept of filing taxes and paying for things and so forth, and be on top of those everyday type financial things. Um, um, One of the things that is always challenging, especially for our higher functioning special needs family members, is it going to be appropriate for one sibling to be managing the finances of another sibling? And that can be, as you can just well imagine, a sensitive topic. Um, I'm a big advocate a of using professional fiduciaries, maybe not as the primary, but maybe as a second or third choice. And here in California, to be a professional fiduciary, there's professional fiduciaries all over the country, but to be a professional fiduciary, there's some very strict regulations. You've got to have a whole series of classes. You have to pass tests. You have ongoing MCLA. You have ongoing reporting to the state of California. And you have to be licensed. You have to be bondable. You have to be able to get a bond and you got to be fully vetted. The rules under the professional fiduciaries, if you're going to take on a special needs trust, you have to have knowledge and education on the special needs rules and benefits and so forth. And so it's something I think that by naming a professional fiduciary as a third role, I think it might make it easier. So if you've named children to assume that first and second role, they know that you've planned that if it's too much of a burden or it's not working out well, you can always go down to that professional fiduciary to step in. I work with several professional fiduciaries, and the nice thing about a professional fiduciary is it takes the emotion out of managing those funds. What you can also do is you can name an advocate. And so sometimes we'll have situations where I had this just last month where I had a special needs family member, adult, and we were setting up a trust. And there was a neighbor who was just um, very, very involved in the family and very involved in the life of the special needs individual. Spent a lot of time, was receiving IHSS funds to care for the special needs individual, but my client said that she was completely incompetent in handling funds, and so she was obviously not a good person to name as trustee. However, we named her as an advocate, and the role of an advocate is to advocate for the beneficiary's interest, and and the trustee has the obligation to listen and take under consideration. They don't have to incorporate the recommendations, but they have to listen and consider those recommendations. Let me see, um, got a few more minutes before 11 here, but I think we can, like I said, we can stay after 11, but I think we'll finish up the core part of our presentation. So trust administration, what is the job of administering a trust? And this
Jeff,
number,
I'm sorry to interrupt you, but
sure.
regarding the professional fiduciaries, there was a question regarding their cost and if there is an asset minimum for the trust that makes sense before employing one.
Yeah, it's usually the quote I usually hear is a 1%. So what's going to be 1% of the value per year. And um, I've had one group here in Temecula that has a $2 million minimum of liquidity. I haven't used them ever since they put that in, because I don't know any of my clients that have $2 million of liquidity. I think there's got to be, there's no hard number, but I would say it would certainly require a minimum of several hundred thousands of dollars for it to make sense.
I've interviewed a couple and my ballpark minimum usually falls around 250,000
Yeah,
and
that's,
not in liquidity, just in net worth.
oh, okay. That's that's more generous. That's better than I would have thought. That's good. Um, any other questions?
Let me go back and see. There were a couple. One was just affirming that a trustee has to be an adult, not a minor.
Yeah, yes, correct. Yeah, you have to be, you gotta be open up checking accounts and deal with money and so forth. So you got to be, you've got to be at least um, an adult, not a minor. The magic age we tend to use, because I have a lot of situations. They say, well, gee, I want to name uh, uh, the sibling to to be the successor trustee, but the sibling is 12. So the magic age, what we often do is we'll name other people, then and add age 25. Age 25 seems to be the number that everybody likes, and I think it's a good age at 25. Either you got to get your act together or you don't. So we'll often say, okay, when Susie's 12, when she reaches age 25, she has the right to take over as trustee. Trust administration. Um, Basically, the trust administration, these are all the things you're doing in your life anyways. You're one of the key things about somebody who takes over a trust is this balance thing. Okay, so the one thing is to make the money last their entire projected life, and secondly, maintain their style of living, and that's a balancing, and oftentimes that can't be achieved. That's one of the balancing things. But usually investing, managing assets, typically if they're a professional fiduciary, they need to use an outside professional money manager, financial manager to manage funds. So it's a good idea that a trustee, it's better if they're not managing the funds, but there's no restriction if it's a family member. Keep books, files, tax returns. Can oftentimes the trustee is serving as an advocate. Of course, housing, caregivers. Again, all the things, maximize the benefits. That's actually specifically called out in the trust that a duty of the trustee to maximize the various government benefits. Oh, and one of the questions I frequently get, is there any personal liability of a trustee? And unless you're stealing money, no, there's no personal liability. There's no impact on that, as long as you're operating legally and appropriately. And generally, why we say the trustee is going to need to be compensation. It's a family member. We always say they're going to be entitled to reimbursement for expenses, and I encourage people to include that. Okay, how do you fund a special needs trust? So certainly, life insurance is a great. I'm a big advocate of life insurance. But you've got to know whether you have a whole life policy or a term policy. Really important. Everybody comes in and says, well, I have a $500,000 policy through my work or something like that. Probably you're going to outlive that policy. It's important. We're going to have a presentation sometime in January on insurance, on life insurance, the different types, and also how it's tied into long-term care. So we'll be pushing that out sometime in the next few weeks on a date on that information. IRAs, retirement benefits, and so forth. Another great way to fund a special needs trust. Matter of fact, under an IRA term, whenever you leave it to a non-disabled person, they've got to spend that money within 10 years. If it's a special needs trust, it's still lifelong. And so if there's significant money in IRA or 401k savings, it can make a difference. I've got two people. I've got two clients, a grand total of two that have $1 million in their special needs trust, and it's all IRA, and most of it's IRA funds. So, anyways, that's I don't know. I don't have nowhere near that, but anyways, a lot of people could have multiple hundred thousands of dollars built up by the time they pass away in IRA funds, and it might be more beneficial to allocate those IRA funds to the special needs trust and other funds to the non-special needs trust, just because of the required payouts. You must identify the name of the trust. And we talked about that earlier. So the specific language, everybody leaving money into this trust, it's got to be specifically in there. And let's see, who needs a special needs trust?
Jeff, I'm sorry to interrupt you. I have
Sure.
just a clarifying question that some
Sure.
people might have. Because we're in a community property state, I would assume that um, those of us who are married, there needs to be some sort of either documentation on file with regard to contingent beneficiaries being the trust or being the outright beneficiary on a life insurance policy if someone still has a living spouse, correct?
Sure. So I mean that goes. We can dwell down into the details of that. But my general advice is for any sort of special needs situation, you name the spouse as the primary beneficiary, and then the family trust as the secondary beneficiary. What you don't want to do is not name either the family trust or the special needs trust as the secondary beneficiary. In the highly unlikely situation, you both get killed in an accident, then the funds are going to go down to the directly to the special needs individual. And then we got all the issues about impact on benefits and having to create a first party trust and spend down things and so forth. I hope that answers a kind of a long answer to a short question, but hopefully that addresses that.
Yes, thank you.
Um, so special needs trust I think primarily most of you are on this Zoom meeting with developmental disabilities, as it with my two children. But we have a lot of people. Mental illness is a huge issue here everywhere. Drug and alcohol abuse, accidents. So there's a lot of other situations where we're using special needs trust. And that's really it. That's my presentation. I can certainly, we're a little bit past 11, so it kind of ends the formal presentation here, but I'm certainly happy to address any other questions, whether it be special needs planning or anything else related to special needs benefits or anything else at this point.
There was a clarifying question regarding the role of the trust maker versus the role of the trustee, whether or not they're the same person or they're different people. And then subsequent to that, if they are just confirming that they can be the managers of the assets of the trust.
So yes, 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 yes. So typically what we see is the same people, that's usually the parents, are the trust makers of the trust, and they're also the trustees of the trust. And yearly they're going to be the trust makers and trustees of the family trust, and they're going to be the trustees, the trust makers and the trustees of the special needs trust. And then they're going to name successor trustees and then if both of them can't serve, then the successor trustees will step in.
And then you kind of have more of a comment, but someone mentioned that adult child support can also be a form of funding a special needs trust in a divorce situation.
Absolutely. However, now this is important to make sure that it doesn't impact SSI. There's got to be very specific language in the court order that provides for that. I have that language buried somewhere in my files. I bring it out to share with my family law attorneys every once in a while. So if you are, and I think unfortunately a lot of family attorneys are not up on this, and so the court order has to have some very specific language in it in the court order to be compliant, that SSI will recognize that as not going directly to the special needs individual and then impacting the SSI benefit. Good point. Thank you for bringing that up.
I have another question. Oh, someone's asking about you had mentioned a backdoor ability to change an irrevocable trust.
Sure. So here in California, we have a statute called that provides what they call a trust protector. A trust protector is one that, so typically when a trust is irrevocable, the only way you can change an irrevocable trust is by going into court. And courts are expensive and slow and expensive and so forth and so on. So the state of California passed a law saying that a trust protector can be named in the documents, and that trust protector can come in and do a couple limited things. modify the trustees and modify the language. So we always include trust protector language in all the special needs trust, and whenever we have a special needs trust, we also put it in the family trust. Over the last several years, I've served as a trust protector about 6 times, and it's been a huge. Four of the times were all special needs trusts. There are all situations where the people that were named as successor trustees, these were trusts that were created a long time ago. All the named successor trustees had all passed away, or they're too old or too sick to take on that role. There was nobody to serve as a successor trustee. This is a situation where the parents had already passed away and there was nobody serving as a successor trustee. Not good, because then nobody has the authority to write checks, make payments, and so forth. So instead of a long drawn out court process, well, all the documents, two of them were I had written, two of them were another attorney wrote. I was able to name myself as a trust protector. I met with the family. We came up with some different names. I was able to modify that irrevocable trust and naming new trustees, and charged several $100s instead of probably several thousands of dollars to go into court, and was able to do it within literally days, a week, or so forth. So if you're ever creating a special needs trust, be sure with the attorney you're dealing with, make sure that they include trust protector language in those documents, so that irrevocable trust can be modified.
Someone's asking if they can sell a house that's in a trust. I'm assuming they mean a living trust, and then put the proceeds into a special needs trust to buy a place for the disabled person.
Sure. So it can be revocable, or it can be irrevocable. So you can sell. So once you have an irrevocable trust, you can still sell assets as long as the funds from that asset go back to that same trust. So let's say you have a special needs trust, and the house has been left into that special needs trust and sitting there, and then for some reason the trustee decides the house is not appropriate, or it's too expensive, or for whatever reason wants to sell the house. Absolutely, they don't have to make any modifications of the trust. They can go ahead and sell the home, and then the proceeds from that sale, you'd open up a bank account in the name of the trust. Remember the rule on how you get something in the trust. A bank account has a title, so you open an account under the name of the trust. The assets would go back into the trust in that bank account that's now in the trust, and those funds can be either used to buy another place, or it can be used to directly benefit the beneficiary, or whatever, as long as the funds are spent for the sole benefit of the beneficiary.
This person has a question regarding Medi-Cal payback. For the basic living trust, Medi-Cal can get payback, where for the third party special needs trust, it's protected from the Medi-Cal payback. Is that correct?
Correct. Under the general family trust, if money is no. So the law has changed under another waiver. So the current rule is that any funds in whether it be a general needs trust or a special needs trust, Medi-Cal cannot seek recovery. They will only seek recovery under the current rule, which is fairly recent. They'll only seek recovery for funds that are in the estate, meaning the funds are not in a trust, and the funds don't have a beneficiary designation. This is California is different than most other states. All the states vary widely, but most states don't have such restrictions. The ability for other states Medicaid boards to recover money is much stronger in other states. That's just another advantage in California.
Okay, someone's asking a question about running a small business out of the trust. Is it better to run a small business out of the trust or start a separate entity? The reason I asked this question is to determine if the assets of a business are counted against our child. For example, reserves and the equipment in the business.
The short answer is yes. Yep. If the if if you have a sole proprietorship, or even if you have a corporation and you own that corporation in your name, that is an asset. And then if you pass away, that asset is going to be available. And if you hadn't planned made any plans, and it's going to go to your special needs individual, and that will impact their benefit. So what we'll almost always do is any sort of business, again, whether it's a sole proprietorship or an S corp or a C corp, we'll put that in the trust. And once it's in the trust, and that's an easy thing to do. And then once it's in the trust, then it won't impact any sort of it will create any sort of benefit issues or recovery issues.
Someone was asking if you can use a special needs trust to invest in real estate.
Um, so the general rule about um, funds in a special needs trust is that it's the prudent investor rule. So they must be prudently invested in safe investments. And um, and so the if you're just managing the trust yourself, I guess nobody was going to stop you. But like a professional fiduciary or a banking or a trust company, they are not going to be buying um, real estate with trust funds. It would really be an inappropriate. I know from looking at California, I think there's an endless upward bound of real estate, and it's a risk-free investment. But in fact, in most financial circles, in real estate is considered a risky investment.
I think this question maybe was asked before, but I think maybe some clarification. Um, so if when the beneficiary of the special needs trust passes, where does the money left in the special needs trust go?
Oh, so you decide. So when you're preparing the documents, when you're preparing the special needs trust, you decide how you want that money distributed if there's funds remaining when the beneficiary passes away.
And then I think there was a follow-up question regarding the real estate investment. They stated that their idea behind the real estate would be to provide passive income for the beneficiary. And then that person also wants to know if your office also sets up LLCs.
Um, so again, real estate is tricky. I think that if you've got rental income, you have a passive investment that's generating income, along with additional liquidity that comes with having any sort of real estate. I think that's probably going to be considered prudent. So that's probably okay. It's a gray area. Um, uh, we, um, we don't do, we kind of stay in our wheelhouse. So we don't do LLCs, but I know there's several other attorneys that I could refer to that are very good and are reasonably priced to do formations of LLCs. I've done it myself. I've done it for my own business and my own nonprofit, but I decided to stay in my wheelhouse.
They're expensive to run here in California, though.
Oh, there is, yeah. So in California, another thing about California, and we get into a lot of discussions. Is it worth having an LLC or some other, people talk about putting rental property in a LLC, and you're talking, um, yeah, at least $800 a month or 1.5% of income. Um,
Um, Okay, if I missed anybody else's questions, please don't make me scroll all the way back. Just copy and paste them. Because there were so many good questions, but I don't wanna go all the way back up. I think I got them all, but if I didn't, I apologize. Just please, write it again in the chat box if you would. Okay, there's one right here. It says, "If both trust makers are incapacitated, would the trust be converted to a third-party trust, or would this happen only after both trust makers passing?"
So So what we're really talking about, I think the question really is, or what we're really talking about is funding, not creation of the trust. So when you actually create the trust, and so when you create when we generally create a family trust, it's going to be immediately funded with assets, certainly the home and maybe other assets. At that same time, we're creating that special needs trust. Now, that special needs trust may not be funded for many years and maybe not funded at all until both of the parents pass away. So if that it makes sense. So it's a different issue. The creation of the trust and the funding of the trust is two separate things. The trusts are both created immediately. Funding for the family trust is usually immediate. Also, funding for the special needs trust can be could be immediate or could be well out in the future.
Okay. I was answering your question regarding how to get started, setting things up. I recommended calling and setting up a consultation, getting a quote, and then if all sounds good, signing a retainer. Um, and then someone had a question I think that I can probably answer, regarding how to fund, or perhaps obtain funding for setting up the estate through the self-determination spending plan. So that's something that I've been recommending people try to do through Regional Center. In full transparency, it's going to take a little convincing, but I do think it's Regional Center's obligation to help families with these fees. But I don't know that they're going to do it willingly on the traditional model. So it's really going to be something that is going to go into a self-determination budget conversation. So anybody who's looking into self-determination, if you don't know what that is, we can chat more about that because that's not really what this um, specific webinar is about, and that's a whole other animal. And I will do a presentation on that again, probably in January. But long story short, it's just a better way of having consumer directed choices and who your vendors and service providers are with Regional Center money. So it really empowers you as the decision maker or the person with the disability in who's providing, sorry, in who's providing their services, versus Regional Center deciding the vendors and all of those things. Um, and he was quiet the whole time until now. But anyway, with regard to the spending plan, yeah, I think that that's something that you can have a conversation with Regional Center about. If you're in the self-determination program, it would be an unmet need that you would have to identify and tie to a goal in the IPP, the Individualized Program Plan. So it's just something that you would want to make sure, obviously, long-term care, long-term planning is an unmet need. And then putting that set aside funds under one of the appropriate codes. And then I know that it's been done successfully for Inland Regional Center for sure, which I'm assuming the majority of us are affiliated with IRC. But if any of you are affiliated with a different regional center, you can reach out and we can chat about that. But yeah, long story short, I definitely think that that's something we should try to take advantage of because I think that it is their obligation to help.
Just a comment. I've got several clients that have gone the self-determination route, and they've all reported that it's been a bit of a chore. But once they've done it, they've been ecstatic over how well it's worked out. So I plan to attend that presentation, Kristen. So
Any other questions?
It's been a pleasure. I love sharing information. So on next Tuesday at 10 o'clock, we'll be talking about limited conservatorships versus alternatives such as powers of attorney and advanced healthcare directives. So I'll be looking forward to sharing information on that. We'll get something out this afternoon, hopefully, on registration and so forth. We have been recording this. I don't know if anybody really wants to sit through our long recording, but we have recorded it. We'll send that out and also be willing to send out charts if you're interested. And so just send us an email and we'll send out an email asking if anybody wants the copies of the recording or charts, and we'll go ahead and send those out.
Yes, and everything's also linked on Go Bananas as well.
Good. Good. All right. Well, if nothing else, I'm going to say good luck, everybody. It's been a pleasure, and hope to see you on Tuesday.
And thank you so much, Jeff. We appreciate your time and your knowledge as always.
All right. Take care. Bye.